Hi, I'm going to speak to you briefly about compromise agreements. In the last couple of years, we've seen a massive explosion in the number of compromise agreements, and we do anticipate that this is going to continue. Certainly, I've been involved in advising on endless numbers of compromise agreements for companies across the UK, all different sorts, whether they're banks, local authorities, and smaller employers as well. The reason for this podcast is I've noticed that there's so many repeat themes that employees and employers actually address and that come up almost every single time when you're advising under a compromise agreement, that I thought it would be a good idea to just perhaps highlight some of these. It could be helpful if you find yourself faced with a compromise agreement or a redundancy scenario that could lead to one. So the main points I want to make, there are 6 of them, but before I do, it's probably worth me mentioning that sometimes people are handed a compromise agreement completely out of the blue. Sometimes it comes because a redundancy process has been started, but sometimes people actually want them, and you can divide employees into 2 main groups. One group will have heard of compromise agreements, probably would have received them before, and the other group probably have never heard of compromise agreements and are quite shocked when something like this happens. But the people that have heard of compromise agreements sometimes actually want to promote receipt of a compromise agreement from their employer because they recognise it as a very comfortable and sensible, mutually agreeable way to part company. So that essentially the one point that everyone needs to understand about compromise agreements is that if you sign one, you sign away your rights to bring a claim against the company, but in return for giving up that right, of course, you are receiving the benefit of a payoff which should exceed what you would otherwise get under pure statutory provisions. Now, so the 6 things, let me carry on to say the 6 things that I think are probably worth bringing to your attention. The first is, obviously, the most important clause in a compromise agreement is how much you're going to receive under that compromise agreement. You have to make that assessment with reference to claims you may or may not have, and that is why the exercise of looking into the deal being offered has to look at what potential claims you may have. Now, quite often it could be that you don't have any claims, and ironically, we do see this quite a lot. People, we look at the whole scenario and there are no claims that somebody has. However, they are being offered a payment which way exceeds what they would ever get if they went to an employment tribunal or brought a claim. So clearly in that situation, it's a very sensible idea to sign up and take the money. But in other situations, obviously, we have to weigh up the pros and cons of the possibility of bringing a claim or negotiating the terms of that payment up to suit that individual. The second point that's worth just raising is that sometimes compromise agreements separate out payments in lieu of notice. Sometimes they don't. And I won't go into the details here because it's a bit complex, but it relates to whether or not there is in your contract of employment a payment in lieu of notice clause, and that can have ramifications on tax and structure with reference to the compromise agreement. The third item that's worth noting is that compromise agreements often contain a repayment clause. So basically, if you breach the compromise agreement or bring a claim, you have to repay the money that's been paid to you. Now, the interesting thing about that is I wouldn't be so troubled about bringing a claim because you clearly know you're not going to if you're going to enter into a compromise agreement. But you have to be slightly careful that you don't breach the terms of the agreement itself, because some terms look quite innocuous, they look quite innocent, you don't perhaps note them, but of course they may be fairly easy to breach. And while a breach of that term in itself doesn't worry you or wouldn't worry the employer, the bigger concern would be the possibility that you have to repay the money under the agreement. Just so that you know, in my 15 plus years of doing this, I've never seen that kind of clause activated, but of course you don't need to be the test case in a scenario like that. Next point number 4, is post-termination restrictions. This is one that's always coming up. Quite often the compromise agreement will simply state that you should you should confirm that you're going to abide by any terms that survive the end of your contract. and sometimes they specifically state you will abide by confidentiality and Post-Termination Restrictions Act clause 13 and 14 in your contract of employment. It's always a good idea to dig out that contract and make sure you understand it and run it by your lawyer if you find that you have got that kind of clause, because sometimes it's a fairly, in about 20% of cases, we do have people phone up afterwards and say, we discussed this post-termination restriction. Does this mean I can't work for that person? Does it mean that I've got a restriction about contacting this client? And so you need to be sure you understand the position there. The next rather powerful point number 5, is the reference. It is a very, very useful tool or provision within a compromise agreement to incorporate an agreed reference. Obviously, in a scenario where there has been a misconduct or performance, it's very important. But in every case, it's nice to know exactly the kind of reference that's going to be provided, and not all compromise agreements contain an agreed reference as standard. So that's something that's useful to watch out for. And finally, another frequent question is the payment for the legal services. Now, compromise agreements are not legally binding unless you have an independent legal advisor, an independent solicitor, or one of another category of advisors review and advise you. And so for that reason, there's often a contribution by the employer for the services. And that's something, again, that you need to be clear on. You need to understand how much the charges are going to be, whether fixed fees are charged as we charge, and make sure that you understand whether there's going to be any additional financial liability for you. So I hope that's helpful. That's obviously just a small sample of some of the issues that can arise if you're faced with a redundancy, a termination, and handed a compromise agreement. But there are obviously scores of others which are general and standard, or which would apply specifically in a particular case. But if you have any questions, feel free to call.